accept your interpretation of that definition, what's the difference between criminal mischief 2 and criminal mischief 3?
I think that's a very good question, and I think it's
because it kind of sounds like if we accept that definition, there is no difference, and there must be, because one's more serious than another, and the legislature chose to enact 2 separate crimes, one being more serious than the other. So.
Sure. I believe the difference would be not necessarily in the result of the property, but that in an individual's intent. For criminal mischief 2, the state needs to establish an intent to damage, whereas for criminal mischief 3, the state only needs to establish an intent to cause inconvenience. So for example, if somebody were to walk into City Hall on a non-carpeted area and dump a bunch of food, for example, there would be no damage, but, or I'm sorry, not that, but their intent was not to damage the floor. Their intent was to bother someone who has to smell it and someone that has to come and pick it up. So I would suggest that would be the difference. In this case, in Mr. Gilbert's motion,
there's a mural on the floor.
If it were artwork,
Yeah.
then that would certainly change the equation. I think that I do think it's very important that that wall is art, because how else, like you said, how else do we distinguish between painting, putting dirt on the floor that can easily be swept up, and then putting that dirt on a piece of art. And I do think that is relevant, because art's function is to be looked at, whereas a floor's function is not necessarily to be looked at, it's to be walked on. And putting dirt on the floor certainly may make it look less pretty, but the floor's purpose has not been diminished, its functionality has not been diminished. I believe that artwork is where the distinction comes in. Okay, and I also would like to make clear for the record that Mr. Gilbert's motion on both criminal mischief 2 and criminal mischief 3 is not ask the court to consider the defendant's intent as to either of those as part of his motion. He has only argued that there's no damage and there was not an interference, but not that was not Mr. Davis's intent. As to the question of it being lawfully directed, let me start with where Mr. Gilbert and I agree. We agree that it is a defense to criminal trespass to say that the order given was unconstitutional. That is a defense. Where we disagree is whether that's an issue for the jury to hear. Questions of constitutionality fall squarely within the purview of the court. The jury does not have a background in constitutional law to understand procedural due process, substantive due process, how to do the balancing act of an individual's liberty interest versus the government's interest in functioning.
Isn't that what jury instructions are for? I mean, they also don't have any experience about what open to the public means, or damage to property. We give them jury instructions and tell them what the law is on that.
Of course, and to that point, it certainly is true that in many instances, the questions of law or the question of fact can sometimes be a little bit unclear. Fortunately, in this case, the court has already told us the proper remedy for defense to challenge the constitutionality, and that's in State v. Koenig, which defense cited in their instructions, and I'll pass a copy of that forward to both parties as well, and then point out the relevant portions to the court. So I would point the court to page 5 of 7 on the top right and start at the very last sentence, which starts with the proper procedural vehicle. And if you continue reading from there, onto the next page, the court says that in the context of criminal trespass and determining whether the order is lawful, the proper vehicle for defense to challenge that is a motion for judgment of acquittal, which is where we're at now. And like I said, I've agreed that this is the forum to make that challenge. And the reason I bring this up now rather than when we discuss jury instructions is because I want to at least make the point to the court that this is, if you were to agree that this is the only opportunity to challenge constitutionality, you should know that and understand that the jury's not going to get another look at it, assuming you agree with our perspective on that. And this case does go on to discuss that balancing interest for a defendant's liberty interest, procedural and substantive due process. And to your point about how, we do give the jury definitions about things and kind of ask them to decide the facts on that. That's true, but it's not their job to interpret the law. You haven't given, there's no instructions for them to know what procedural due process even means.
What's that is if we give them to them. I guess here's what I'm thinking about with Koenig, because I'm reading what you're reading about. It says the proper procedural vehicle for challenging the sufficiency of the state's evidence in this case was a motion for judgment of acquittal, a motion that defendant in fact made. And that statement is certainly true as far as it goes, but that is in the context of contrasting such a motion with the motion that is, I think, not appropriate, which was, I think, a pretrial motion to dismiss, I think is what they talked about. Maybe I'm thinking of a different case.
No, you're correct. There is another procedural point to it.
So just because something is the proper subject of a defense motion for judgment of acquittal doesn't necessarily mean that it's also not a proper question of fact for the jury, given the proper jury instructions. So that statement here doesn't tell me necessarily that I should just be the final word on the constitutionality and take that issue away from the jury.
I totally see what you're saying, and I wish that the court was crystal clear on that point, and frankly they're not, and I totally see that different perspective. However, to the extent that we need to make a decision interpreting what the law on the issue is, I think that the court's language of saying the proper procedural vehicle, it doesn't say one proper vehicle, it's the proper procedural vehicle is motion for judgment of acquittal. I think that's pretty strong evidence that the court intended for that to be an issue for the court. In contrast to person in charge, which would be a clear issue for the jury to decide. They get a definition of what it means to be a person in charge, they've heard the evidence, and they can link those two things. But to ask the jury to do a balancing act and provide them what would take likely dozens of pages. I know how long it took me to learn what procedural due process was, and I'm still learning. It doesn't seem like the type of decision that when the court said the proper procedural vehicle, they were intending to leave open for a jury to decide. And essentially, we can give the jury a little bit more guidance on what procedural and substantive due process means, what freedom of speech means, but we'd essentially be asking them to go off feeling.
Well, and I think I take your point with regard to how difficult it would be to instruct the jury with regard to procedural due process. And I just want to clarify that you agree that that's not the issue in this case, right? This isn't an issue of procedural due process that the defense has raised. It's the lawfulness of the order doesn't, and I don't take their argument to be raising any procedural due process problems with the lawfulness of the order.
Well, frankly, I'm still unsure what constitutional provision defense believes was violated here. I'm still unclear as to that, but what I can tell you is that in defense's instruction, that proposed instruction where they ask for the jury to consider the constitutionality of it, they're citing Koenig, which is discussing procedural and substantive due process. I did add those terms that didn't come from defense, but for defense to just say, hey, jury, they haven't proved this was a constitutional order, that it doesn't really mean anything. Was freedom of speech violated? Was freedom of the right to assemble violated? Did he not have proper procedural due process to contest the ejection?
See, I think it's both of those first two things, not the third, and then in addition to those two things, the ability to, what's the phrase, Mr. Gilbert, seek redress for grievances from the government?
Yes.
Is that right?
Right.
I think it's those three
Okay.
things, right, Mr. Gilbert?
Yes, Judge.
Okay.
Okay, so then let me turn a little bit towards the actual lawfulness, and I do want to cite State v. Margaret, which was also cited by defense in their jury instructions. And just because I have it here, I'll pass those. Would it be repetitive for me to briefly tell you the facts of this case as the state sees them? Oh, okay.
Actually, I'm not as familiar.
Okay. This is the facts of this case involve a meeting at a public building, a public forum, and the defendant in this case wanted to speak about an issue. He wanted to conduct a cross-examination, and he was denied that opportunity to cross-examine. As a result of that, he became very disruptive, yelling. And as a result of that disruption, he was ejected. And what the court said was that the ejection was lawful because the basis of the objection was not that they were trying to silence him by not letting him cross-examine. The issue was that he became disruptive. And so what the court makes clear in State v. Margaret is that disruptions in a public forum setting is a basis for an ejection.
Good, not the mayor.
And
Good fighter.
and the relevant portion that I cited would be the bottom right paragraph on page 3 of 4, starting with defendant does not challenge. That entire paragraph encompasses what I was just saying.
Jesus Christ, these guys take a lot of time.
Okay.
And that's also why I had asked that, I had added in that special instruction that point about disruption. Because even though I was anticipating asking the court not to send that issue to the jury, I think if it is sent to the jury, that they should be given the law a little bit of guidance as to what they're looking for. And if the jury, I believe that this case says that if the jury were to find that the basis of the exclusion was a disruption, then they would be able to convict on criminal trespass. And then I do have one other point on criminal trespass that's, I believe, boxed off from this. So before I move on, I'm wondering if you have any other questions you wanted to pose to me.
Not about that. I'm gonna have some questions though for you at the end, just again, about,
Sure.
circle back to the whole procedural issue about whether or not it's appropriate for me to decide that issue at this stage.
Sure.
But anyway, we'll get back to that. But go ahead and go on to your other argument first.
The second, and what I believe is an entirely boxed off theory for criminal trespass, is that the defendant entered or remained when the premises was not open to the public. And that component does not require that a person with authority told him to leave, and it doesn't have those same constitutional requirements, because he's not being singled out and told you need to leave this public forum. When city council ended the meeting in clear chambers, that was closed to the public. There was no public forum happening. And his very presence at that point in time is a criminal trespass. Now, we could definitely have a discussion about, well, it's gonna take some people time to stand up and get out. Once they say meeting over, is everybody in there automatically trespassing? And of course not. And, you know, Mr. Gilbert's example in cross-examination about being in a Safeway and it's past closing and you still wanna buy something, are you trespassing? And it can be a little bit tricky sometimes how we look at that, but the major distinction is that in Mr. Gilbert's example, you went up to a Safeway employee and said, can I buy this? And they say, sure. If that Safeway employee told you, no, you need to leave right now, it doesn't matter whether they have authority to trespass you or not. The building's closed and you have no reason to think you have permission to be there. And that's essentially what happened here. Chambers was closed to the public and Mr. Davis refused to leave. And he remained in a place that was not open to the public. And I believe that's